All right, well, good morning, folks. It's 11:01 in Enfield, and I doubt anybody's in a different time zone, so I'm guessing it's 11:01 where you are as well. I will take the liberty of getting started. I see 7 of us, and I'm hoping that's enough, that we don't have quorum issues. I know a couple of folks had last-minute conflicts, and they're going to be unable to join us, but we have what I think is a productive agenda for the morning. We've made a couple of changes that I think will be well received. But we'll get to them in just a minute. One quick administrative point, credit to Karen Foley O'Connor for catching this just a moment ago. We have a couple of different versions, and I myself, I've got so many versions of this saved. Sometimes when I pull up what I'm working from, I'm not even confident I'm always working from the correct one. But you will have an email from Karen from within the last 15 minutes or so. If you are dual screening it and you are working from an actual model policy that you're looking at while we are working, it's highly suggested that you use the one that Karen sent out a few moments ago. That's going to be the most up-to-date version, and we appreciate her attention to detail and catching that one at the last minute. With that in mind, we will, it almost seems a little redundant because we're at a point where everybody knows everyone else, but it's a pleasure to see everyone again. We'll allow the floor to be open and folks to introduce or reintroduce themselves as the case may be. My name is Alaric Fox. Very much my pleasure to join you, and I continue to serve as the Enfield Chief of Police. This would be the part where anybody else that wants to go can go.
How about I'll just run down the film strip. Karen Foley O'Connor, CEO of the Network Against Domestic Abuse, also up in Enfield. Merritt, you're next.
Joy, the complaint officer for the Office of the Victim Advocate. Good morning, everyone. Good morning, Nancy Tyler. I am the survivor representative and part of CCADV.
I got Liza next.
Liza Andrews, Vice President of Government and Public Relations for CCADV.
Andrea.
Hello, everyone. My name is Andrea Deo. I'm the Director of Law Enforcement Services for CCADV. Just wanted to let you know that Kirsten has attached that model policy, the updated one.
And Chief, I'll just let you know that Andrea just advised me that Chief Rosado is going to be coming on about 10 minutes late.
Great. Not great that he's late, but great that he's joining us. Anyone else on the film strip?
Yeah.
Very good then. Okay, approval of the February 25th minutes. That was our last time together. This also came out with yesterday's email. I took a look through it and I was comfortable with it, but I will allow anyone that needs more time to please feel free to take a look at it. And if there are any additions, corrections, deletions, or concerns, please speak up. If there aren't any, I would certainly happily entertain a motion to approve.
I will move to approve.
Thank you. Do I have
I'll
a second?
second.
I have a second. I'm sorry.
I'll
All in
second
favor?
that.
I have a motion. I have a second. All in favor? Anyone against? Anyone feel the need to abstain?
Johanna Canning here, and I apologize. I jumped in a little late. I was trying to print out the new policy that was just handed out. What are we approving right now?
The February 25th, 2025 minutes.
Okay.
Minutes from the last meeting.
I'm in agreement with that. Thank you.
Thank you for the clarification. Motion passes, minutes are approved. We can now turn to the substantive areas of discussion. And again, as I mentioned earlier, I think these are going to be well received by the group. There shouldn't be any, I don't perceive any controversy, issues, or concerns. And I think that you will find them worthwhile additions. The first item up for discussion, if you are working from, actually, this is going to be from either version, yesterday's or today's. If it's helpful to you, I would draw your attention within the model policy down to pages 7 and 8. And I'm going to defer to Karen Foley O'Connor in just a moment for a more detailed description as to what we're doing here. But the 50,000 foot overview is that what you see in the red which is the lap is voluntary and highly suggested, is going to be replaced by what you see highlighted in sort of the aqua, which is that the lap is going to be mandated. This is clearly a 21st century domestic violence law enforcement type of practice. It has been well received within the law enforcement community. I believe I'm correct when I say that there are no departments that are not doing it. So there's not even going to be gnashing of teeth from the law enforcement world. But please take a look at what you're seeing in red, bottom of page 7, in aqua, top of page 8, and I would invite Karen to further educate and clarify.
So thank you, Chief. So we're removing the red because it kind of alludes to the voluntariness of the program, and moving over to basically add some, again, this is geared towards law enforcement. So the reasons that an officer would choose to do a lap. And this is literally taken right off of the lap sheet. Actually have one right here where an officer would read at the top when to do a lap. So what we did is we put that word shall conduct a lethality assessment when one or more of the following exists, and each of those are listed as they are listed on the instructions on the lap sheet. And then we thought it would be important to say that the officer conducting the screen shall follow the protocols that go along with whatever that screening result is. And then points to a resource for training for officers. So I think that we've accomplished what we had that's important in the previous piece that we're removing. And I think we're making it pretty clear that these are shalls and follows the protocol of the actual program.
Thank you for that, and I would again just echo my I guess my same comments from a moment ago. When the lap protocol first came out, I mean it was certainly newer by definition, and in my world, we like the way that things are. Sometimes that's a benefit, and sometimes that's a detriment. So in terms of the adoption of the new lap protocol, everything that we do in the law enforcement world, maybe everything we do in the criminal justice world, we tend to inch along, not sprint out in the front. So the lap protocol was rolled out. Everyone went on board, to my knowledge. At least that was the last update that I have. So this not only codifies this as more than a best practice, it moves it into the mandate. And and not that I would find this to be dispositive, but I have experienced no pushback at all from my law enforcement contemporaries. I would welcome the floor up to any comments or thoughts on the lap modification language, pages 7 and 8.
I lost my video there. I do have a question. I note that I'm sorry, I'm just struggling with, I didn't print this new piece out in color, so I'm trying to go back and forth, make sure I have this correctly. The old language stated that across the state, the law enforcement voluntarily engages in this practice. Is that being removed entirely, or law enforcement agencies that voluntarily participate? Is that language being removed entirely? Are we no longer noting that they voluntarily participate?
Correct.
Yes,
So I'm sorry, go ahead, Karen.
I was going to say we removed that entirely because initially, as the program came out, it was a volunteer joining into the program. Since then, Connecticut, all law enforcement agencies are volunteering, and the volunteer is actually within an agreement between the agencies and the police department that we're going to work together with LAP. So those exist. By putting this here, this ensures that that officers shall do it as an entity because the model policy is the minimum standard by statute. So by utilizing the word shall in this, it ensures that if these circumstances, one or more of the following exist, that officer does conduct the lap, and even more importantly, that they follow the appropriate protocol based on what the screen result is.
So maybe I'm missing a point here, but is it not better to have the language stating that that those agencies that are voluntarily participating shall then, as opposed to just saying shall, because now you have it's a voluntary procedure and you're making it mandatory without going through the legislature. You're just putting it into the model policy.
So the voluntariness is to join, but I do believe that once, and Chief, you could speak to this, once you're in it, you're doing an MOU to basically into that agreement. And that's sort of the point. We want to make sure that this stays in place and that law enforcement, which has been an incredibly valuable tool, that law enforcement doesn't decide, well, nobody's talking about this anymore, so we don't have to do it. So that was the whole one of the recommendations that came out of our whole council, that we wanted to make LAP a requirement in utilizing the model policy.
Okay, so we're not saying that for those that are voluntarily entering this program, you shall do it this way. We are saying now that all law enforcement in Connecticut shall do it this way. I just want to clarify.
Correct.
Yes, because all law enforcement in Connecticut are doing it. I actually think, Liza, wasn't Connecticut one of the first states in the country to get full compliance from law enforcement within the state?
Correct. I think
I do
so.
understand the confusion, and perhaps I can clarify. We are not saying that you can voluntarily participate, and if you voluntarily participate, you shall do it this way. What we're saying is that everyone has to do it. If it's helpful, and I understand, because I try to avoid printing in color as well, because my IT folks get very angry with me. What you're seeing at the bottom of page 7, which is kind of like the last full bullet, and then that one bullet that's inset a little bit. So all of that is out. So what you're going to simply jump down to now as to LAP is where it begins currently, assuming that our paging is the same. The top of my page 8, which is the bullet that says officers investigating domestic violence cases shall conduct lethality assessment. So there's the shall, that's the mandate. And then this is when you're going to do it. And then the officer conducting the screen shall follow the appropriate protocol according to the results of the screen. A final flourish on what Karen alluded to a moment ago is that in the police world, what winds up happening in all of our worlds, but when this becomes the new model policy, Post pushes it out to all of our agencies as the mandatory minimum, if you will. So by getting rid of the red and adopting the blue, all police departments across the state will be bound by this as a post mandate, because we effectively have the statutory authority to cause this change, which Post then has to follow. I do understand the confusion, but I think that what we are achieving here is everyone's going to have to do it, and that when you're doing it, you will follow the protocols. Is that helpful?
It is helpful. Thank you.
Thank you.
One further question. Is there any language in here that has changed since yesterday's model policy came out? The one that was sent yesterday?
Not for this particular
Not from
bullet.
this
I'll
section.
point out when we get there.
Okay, great. Thank you.
All right, hearing no objections, and I'm not sure, I mean, I don't know that we need to vote on each individual change, assuming that there's no dissension from within the group. So why don't we take the liberty of just moving on? The agenda has us jumping to other business at this point, and I'm not sure, perhaps that can be deferred to later on in the agenda, and we can stay with the model policy. What would be the reference to Roman numeral 5, coordination with the rest subcommittee. If you're scrolling down, I would draw your attention, the substantive significant changes are going to be on 12, 21, and 22, but there is one relatively minor change I would draw to folks' attention on page 9. And again, if you've colored it, you're going to see it in the aqua. If you didn't color it, it's going to be under supervisor. And it's going to be the first, second, third, fourth bullet down. Upon approval from the court, expedite the arrest warrant execution as soon as possible. Karen, did you want to comment on that?
Just comment to the fact that this is because we're in supervisor only section here, this is going to get even more, the language becomes stronger as we move to page 12.
That
So
was my
if we'll- Yep.
my perception as well.
So if we go to page 12, and this would be, this should be correct in your in the yellow version, if those were looking at the yellow version of the previous version. Under arrest warrant considerations, at the third bullet, if an officer an officer must be sought in any involvement involving the use or threatened use of a weapon, electronic defense weapon, an officer should expedite application of the arrest warrant, and this is a known practice within law enforcement, but is not listed here, that an officer should consider contacting the state's attorney of that jurisdiction in order to expedite the review of the arrest warrant. So this alludes to what we commonly refer to as in law enforcement as walking it through, meaning we're making a phone call ahead of time. We're letting the state's attorney know that, we like eyes on it quickly. And then the state's attorney will take it from there to try to get it walked through to a judge, to hopefully expedite that warrant coming through. And I'll keep going unless anybody has any questions on that, or do you want me to just go through them all? Go through them all,
Please.
and then we'll go for questions. Okay, we left that fourth bullet, and then the following bullets are all new and all deal with expediting. And I believe the points that we talked about in our last subcommittee meeting. So the first is that the agency should make an attempt, once that warrant comes back, make an attempt to make certain, I know I put attempt in S, like maybe more than one attempt, to make service of the arrest warrant as soon as practicable. Investigating agency shall make repeated attempts to serve the arrest warrant until the offender is arrested as appropriate to the circumstances of the given case. The investigating agency shall ensure that attempts to serve the warrant are not hindered by personnel on days off or extended leave, and should consider reassignment of the case in order to expedite service. And last, we dealt with the victim contact piece. Once a domestic violence arrest has been served, the investigating agency shall make attempts to notify the victim of the arrest. If the offender is held on bond, explain to the victim that the offender might not be held overnight and may be released shortly after arrest. The investigating agency shall provide the victim with the appropriate contact information for the investigating agency. Victims are to be encouraged to call the investigating agency at the number provided for periodic updates as to the offender's incarceration status as they deem appropriate. I'll just say that language was taken right from the language that we use when we talk about victim notification and contact when an officer is at the scene of a domestic violence arrest. If an officer is at the scene making an on-site arrest, they're required to provide contact information to the agency as to where the offender is held. They're required to encourage the victim to call as often as needed, and per policy, desk officers and dispatchers are required to entertain any call from a victim regarding offender incarceration status. So it's the same protocol as far as if they make contact with the victim. I mean, we can require that they attempt to contact the victim if they've served a warrant, but unfortunately we cannot know that they will be able to successfully attempt that victim, but they need to make those attempts.
Could I ask one question here? Would it be possible to add to that sentence that the agency would at the same time notify the victim of the Safe Connect information? I'm just thinking, we're calling the victim to say this person may be out within 24 hours or sooner. Would that not be an appropriate place to again say you've got some resources if you need a safety plan?
So we could, but it would be redundant, because if they've made an arrest, they're required to follow several other necessary steps, including the domestic violence form, including a victim's rights card, including and those will all be in the officer section, you'll see. So if the warrant's been served, they're going to be required to do all of that anyway. I do think that you make a really good point in that what if the victim's calling and saying, have you served it? And they say, no, we haven't found, we haven't been able to serve it yet, that they provide that information. I do believe that we're covered in what they're already required to do anyway. That would be protocol. But any thoughts on that from anyone else?
I know that it is achieved at earlier points in the process, as you've alluded to.
So any other comments or concerns about this particular issue that we were tasked with working on? Good. Okay.
All right, then I guess we draw down further. The next place of concern, as I scroll down, I believe is around 21, 22, 22 exclusively. So let me tee this up, and then again, Karen always brings it home quite articulately. There was a practice, and I actually remember this. It actually dates back to, it's got to be 02, 03, 04, because I actually remember where I was in my state police career when this new protocol rolled out. Those of you that have been at this for a while will remember that there were a couple of horrific events involving individuals that were, I mean, there were many horrific events, but these were two that gained a great deal of attention at the time in that 02, 03, 04 timeframe. There was one in Plainfield, and then there was one in East Haven, West Haven, on the town green at a 4th of July concert. And what these events had in common was offenders that were required to divest themselves of firearms under court orders, and they had not done so. Quite significantly, they had not done so. And then they took those firearms and they caused incredible carnage, generally, and to the victims specifically, at these specific events and these specific locations. What flowed from that was what I would call a working protocol that was signed off on by the Chief State Attorney's Office at the time. The state police signed off on it. We had a commissioner by the name of Arthur Spada, and that's how I remember it, because I remember Spada being involved in this. And the Chiefs of Police Association, the CPCA, signed off on it as well. That protocol has stood strong and has been followed, we believed, exclusively or uniformly, I should say, for the better part of the last 20 years or so. But the downside of having things as sort of like that's the way we do it and not reducing it to a policy is that sooner or later you find the agency that maybe isn't doing it that way. And I believe we've had at least one or two of those uh-ohs that were uncovered or came very close to being uncovered, or were uncovered. They came very close to being potential bad situations. So what you're seeing, and this is queuing it up for Karen, what you're seeing largely in the blue on page 22 is the memorialization of what has been a standing practice, but moving it from that old working protocol into the model policy. And with that in mind, Karen, you can do much better than I can.
So, and I will just start this by saying that this was not something that the whole council put forth as far as something they wanted us to tackle. To be honest with you, we started talking about it because I personally came across a couple of cases where we had an offender who was not following the 24-hour rule and showing compliance to showing that compliance to State Police Licensing and Firearms Unit. And we started doing a little dig around. I got Sergeant Maurice from SLFU involved. We couldn't really find anything anywhere that talked about what the police department's responsibility is if they're notified by SLFU, hey, this person who is ineligible to possess weapons has not shown us that they've complied with either selling their weapons to a federally licensed firearms dealer or turning them over to law enforcement, surrendering them to law enforcement. So we looked, I saw one department's language that said that the police department shall follow up with the compliance. And in my mind, this isn't a follow-up, this is an investigation for an attempt or a potential criminal possession of a firearm by someone who should not have a firearm and is a DV offender and subject to an order. So we got together and we looked at, talked about best practices, and we felt that there was nothing to talk about urgency, like we were like the issue we had with arrest warrants and the service arrest warrants. So we decided to try to tackle this here, and I do think, you know, that the warrant work that we just did, as well as this work, I think our intention is to pass this on to the warrant subcommittee to take a look at these, because this is part of part of the things we're looking at. But let me just go into here and show you where the changes are. So Joanna, this is one that's different from what you have. So you're going to be looking, go past the yellow, and then there's two bullets past that yellow portion, I believe. Person subject to restraining, person subject to conditions of release. The next one, the state police special licensing, is the suggested new language. Basically, and this practice is encapsulated in an MOU that the chief just spoke to. A new one was done in 2016 when the 2 business day rule went to 24 hours. So all of this language came right from that MOU. That they shall track the subject's compliance as it pertains to any order impacting the ability of a party to possess a firearm or ammunition. If a permit holder fails to comply with the statutory requirements of transferring all firearms and or ammunitions within the required period of time, typically 24 hours, a letter of non-compliance will be sent to the state police troop or police department where that subject resides. The police departments and state troops shall then investigate the non-compliance ineligible subject as soon as practical. So once they receive that, they should go out and check on this person to see if they've turned over their guns or if they're in possession of weapons. If weapons or firearms are produced by any ineligible subject, he or she shall surrender any and all firearms, weapons, and ammunition to the investigating law enforcement agency as required under law. This next section refer to this one that cites federal law. That's being completely removed because it changed in 2023, and that's going to be addressed in the bottom 2 bullets. So that's we're suggesting that be completely removed because it's inaccurate. Upon the surrender of firearms, that remains. And then adding, if the eligible subject fails to account for any and all possessed firearms or weapons, investigators should consider an arrest for criminal possession of a firearm, and the statutes or cites. Persons convicted of a misdemeanor violation of any law in the state that have been designated family violence crime pursuant to section 46B 38H for a crime committed on or after October 1, 2023 is ineligible to possess a firearm, electronic weapon, and ammunition. And then it addresses it again, basically tying the federal law into state law, which is why we removed that that bullet above referring to that federal law. It's one of the benefits of having someone like Sergeant Brianna Maurice helping me as I'm writing this. She spots something right away that needs to be updated. So that's what those last 2 bullets for. So I am really interested in discussion about this, because this was something that we've just been discussing. I've been discussing it with Sergeant Maurice. I've been discussing it with Chief Fox. We just figured we're talking about urgency. This is another area where victims are very concerned that they know that their person that they have a protective order, that the protective has weapons. Have they turned them over? Am I safe? So we felt that that urgency should also apply to here and apply a strategy for it so that officers understand what's expected when they receive that non-compliance from SLFU.
Floor is open for any comments, questions, concerns, suggestions. What we've done is we've memorialized what was the protocol for 20 or 25 years, updated what was the protocol for 20 or 25 years, and ensured that we're not going to have hopefully, situations where some errant department or errant officer says, we didn't know, we forgot, and they didn't do what they were supposed to do. I was astonished when Karen shared with me that she came across an agency or two that in a given case was either at best unaware or inattentive, and frankly quite frustrated by that. There's one errant bullet at the bottom of the new sections, right above permit to carry, that my OCD would like us to remove. But other than that, I'm very good with all the language.
And I would just also add that we may have to just relook at the table of contents if we are shifting things around.
Yeah.
Any discussion on, because this wasn't something that the group came up with, we kind of went rogue and did it on our own because we thought it was the right thing to do.
You didn't
And-
go rogue, Karen. The subcommittee still exists and can talk amongst itself of other changes, because the changes that you're proposing as the subcommittee, you're proposing to the full council for approval.
So
I think this
seeing-
is great.
Thank you.
I think this is something that will really help. It's something that we've talked about in our other subcommittee, and I think will help with the compliance. I did have one question. So it says, where is it? If the weapons or firearms are produced by the ineligible subject, he or she will surrender them. And then if they fail to account for any of the possessed firearms, that's when the police should consider an arrest. Are they only considering an arrest if they don't produce them? Because my question is if the licensing unit is sending a non-compliance letter to the police because the person has not complied, so now the officer has to go out and get the person in compliance because it's after the 24 hours, and they produce them then because the police are at their door, could there be a charge there, or is there not going to be a charge there?
I would argue that would be case by case.
Okay.
Sometimes you go and they said, oh, I did, and here's the paperwork. So they were in compliance. I'll just share a scenario I was talking about is went to get guns. One gun was not, they were in compliance because one gun was missing. He said she had the gun. She's proved she didn't have the gun. And the officer was like, well, what do I do? I can't prove she took it. I can't. And that's the scenario where it's the gun owner's responsibility was ineligible to produce that gun. And if they can't produce that gun, then a charge should be considered. So I would, Rick, do you want to add to that? Like, I would think case by case, there may be a reason somebody couldn't get their weapons to surrender. Chief, what are any thoughts?
Yeah, I mean, I far be it from me to start making arguments that in essence are the pro-defendant arguments, but I can think of instances as well where, I mean, the one obvious one that comes to mind is the person might still be locked up. So they didn't comply, they couldn't comply. If the charge in that God forbid category was serious enough, the person remains in DOC custody, the notice is getting sent that they have to turn in their weapons, they're really not in a position to do so. That would be a compelling example. I could also envision a situation where the person, the letter got sent, and the fact that somebody didn't get the letter doesn't mean that they get a pass on the statutory requirement. But I can also envision situations where somebody didn't get the letter, they were out of town, they were out of state, maybe they're at a halfway house, they're at a sobriety house. I can think of some instances where, and far be it from me to make the defendant's argument for him, but I'd like to think the policy should recognize that maybe a little bit of wiggle room post 24 hours in some limited cases might be warranted. I mean, the point
Makes
is well
sense.
made. Yeah, but we're trying to reconcile the policy with some of the real world situations that I know that at least the two of us have encountered.
Yeah,
Andrew, I
absolutely.
think
No, that makes sense.
what gets me like jazzed up about this language is that
Mhm.
it's not a follow-up on compliance. It's an investigation of criminal possession of weapons until you deem it's a compliance issue, right? So I like the fact that we can change the language from, they'll follow up to, hey, no, investigate what the
Right.
compliance issue is. So and that's the way, I mean, for the most part, law enforcement does everything. We're going to start,
Mhm.
it is what it is until I can prove it's not a crime, right? So that's really our goal, just to kind of impress upon agencies that this is an investigation, inform, and again, these documents, we want it to be helpful, right, to law enforcement, inform that there is something you can do if you're kind of stuck in that catch-22. Bottom line is someone responsible, if they have firearms registered to them, they're responsible to produce those.
Awesome. No, I think this is great. I think this is a great progress to where we're heading.
Thanks.
And I believe that brings us to the end of the changes, yes? So as a matter of protocol, I don't know if it's necessary for the subcommittee to vote, but I certainly don't think it's going to be a problem because I think we all are on board. So I will, I suppose, solicit a nomination or a recommendation that we pass these changes as suggested and advance them to the broader council for consideration. Do I have a motion?
If I may.
Please.
Okay, I'll let you go first, Attorney Canning.
Thank you. So maybe we can do this by subject, because the first two subjects I have no issue with, and I probably have no issue with the third one either. I just need to run some things through some of my higher ups, so I'm unable to vote on that issue in particular. The first two I'm fine with and have no issue. So maybe if you want to go topic by topic, we can, I can vote on that.
I also
Okay.
just wanted to ask, and this may, I've lost track of which ones. Karen, you said we're going to the arrest warrant subcommittee, but did you say that some of these were in conjunction with the arrest warrant subcommittee and have they, I don't know, Gail, have you all as a subcommittee already seen these?
My thought was that the LAP language is ready to go. If we're good, is ready to go to the full committee. My thought on the arrest warrant language
And the
should go
firearm
to the
language?
warrants. Yeah, because that was what we agreed, that we were going to coordinate, let them take a look at it. And then while we were doing this, things that you need to kind of do quickly, that's how this weapons compliance kind of fell into it. So it's hand in hand, even though they're not exact same issue, they sort of are. This needs to have a sense of urgency, right? So I felt that those two should go together to the warrants committee.
Okay, so I guess that was my question. So then really what you're potentially voting on as a subcommittee is for that LAP language to be presented to the full council for its consideration. And those second two, the arrest warrants and the firearm compliance, to go over to the other subcommittee for their review and discussion, and then on to the full council. Is that ultimately what you're saying?
That's where my mind was at. Chief, are you in agreement?
That certainly works for me. So now there will be two motions. If I'm hearing the suggestion, which I do appreciate, if I'm hearing it properly, the first action that we would take would be on the LAP. And I suppose that one errant reference to supervisor should be included in that one as well. That is within the province of our committee to act upon as a recommendation of the full committee. So that's going to be the LAP language that was in the versions I'm working from, page 7 and 8. And then that one very small reference under supervisor to as soon as possible that's appearing on page 9. If we box those two up together, do I have, and again, I appreciate the clarification, do I have a motion within this committee to approve those changes?
I'll make a motion.
Okay. Do I have a second?
Second.
I have a second. All in favor by show of hands? Okay, so we are good on that. The second bracketed items, if you will, sort of trying to also reconcile what is the province of this committee. Here, and this is in the subject areas of what I would call walking the warrant through. And that's going to be the changes that are largely on my page 12 spilling over onto 13. And then the language that sort of memorializes what has been the operational protocol and now formalizes it is page 22. Our committee's feeling on that is that that is more properly referred for consideration to the arrest warrants subcommittee. So I would entertain a motion that this committee lateral, for lack of a better phrase, this information to that committee, warrant walkthrough, and then the surrender protocol. Do I hear a motion on those two items? I have one. Do I have a second?
Second.
I have a second. All in favor by show of hands. Against, or a decision to, do I have anyone against? I do not have anyone against. Any abstentions? I got an extension, and one abstention. Okay, so that would pass, but certainly as a working group, if there are any concerns, we'd be happy to hear them at any future point. If that's something that our group needs to hear. And just as we are sort of transferring this recommended language to the arrest warrant subcommittee, any language or any concerns, any language changes or any concerns, I'm sure we would similarly be willing to pass those on as well. That's a clean way to do both of those matters. So I appreciate the guidance from a couple of you in particular. All right. Anything else on the policy, the recommendations, both that is ours? I think we're good on all of that. So I'm a little bit out of order, but that was by design. I believe this would now bring us down to other business. Any other business that anyone wishes to bring before the group?
I'll
Karen?
just would like to add, I do have the last MOU protocol that was signed in 2016 when the time period for eligibility went from 2 business days to 24 hours. It's the most recent document that we could find. I'd be happy to share that with the group, to also be forwarded on to share with the warrants subcommittee.
That could only be helpful. Thank you. Final call for any other business. Hearing none, while we have everybody together, do we want to grab phones and try to see what the appropriate time and date for our next meeting would be?
We're actually already scheduled. We're scheduled.
And could you remind me?
Yep, it's June 10th.
For
Actually, it looks
11.
like it's already got a Zoom. I didn't even.
Sure
So
enough, here it
note
is.
that I had sent an invite out, and then we get a separate invite from the legislature. I sent them out way early, so be aware, you might want to take that mine off your calendar, so you're not waiting in a
Karen,
Teams
I'll
room.
resend it with the link that was given to me.
Okay,
Yeah,
Thank you
and
both.
that'll be post the legislative session, so we'll also be back to a hybrid option for that meeting.
And are we aware, do we have any homework for that June 10th meeting? I mean, I don't want to have a meeting just to have a meeting, but I'm also wise enough not to cancel it because then calendars fill. Is there anything other than what we might think of between now and then? Is there anything that we have to accomplish specifically before that June 10th meeting?
I think we're waiting to see what comes out of the legislature. If there's anything that we might need to make adjustments, then we can keep an eye on that
Okay.
until that date.
Okay.
Anyone else?
Then let's hold it, let's keep it, and let's see what happens. But I'm certainly very pleased that our group has gotten this, at least to the extent of our collective knowledge right now, as close to the finish line as we think is appropriate. Last call, anybody, anything? Hearing none, I would entertain a motion to adjourn.
So
I have one, and I have 2 hands, so one will be the first, one will be the second. All in favor? Thank you all. I wish you a good rest of the day.
thank you.